You're listening to the North Star Law Firm podcast. Clear, practical analysis of tax and bankruptcy matters that affect business owners and individuals. Each episode breaks down a current legal development and explains what it actually means for the people who have to deal with it. Brought to you by North Star Law Firm in Houston, Texas. Here's today's topic.
Right now, across Houston, there is this very specific, just a really intense kind of anxiety happening. And it usually starts right at the mailbox.
Yeah, that's exactly where it hits them.
Right? A small business owner, maybe someone who, had to close their doors a year or two ago, they open a letter. And it has a government seal on it.
Which is terrifying enough on its own.
Exactly. But the really terrifying part isn't the seal. It's the name on the envelope.
Yeah.
Because it doesn't say the name of their LLC or their corporation.
Yeah.
It has their personal name on it.
Oh, yeah.
And suddenly they're staring at this massive, six-figure demand for a business loan they thought, died with their company.
It is just a terrible moment of realization because, you spend all this time and money setting up a corporate entity specifically to prevent this exact scenario. You're taught that the corporate shield protects your personal life. But in that moment at the mailbox, you realize the shield is not protecting you at all.
And that moment of panic is exactly why we're dedicating this deep dive to understanding the mechanics of government business debt. We are synthesizing a lot of ground today. Federal Treasury collection guidelines, recent bankruptcy court rulings, and some really hands-on insights at North Star Law Firm here in Houston.
Right, because there is a lot of misinformation out there right now.
So much.
Yeah.
Our mission today is to walk you through exactly how these collections work, what the government actually can and cannot do, and how you navigate out of it.
Right.
Because the reality is, the most important page in your entire loan file was not the interest rate. It wasn't the repayment schedule.
Well, not at all.
It was a single page, usually titled something like Unconditional Guarantee, that most owners just signed without fully understanding the legal mechanism they were triggering.
Yeah, to really understand the predicament, we have to look at the mechanism of a personal guarantee because it is essentially a quiet, voluntary undoing of the very protection you paid a lawyer to set up when you formed your company.
I always like to visualize the corporate shield as a physical brick wall, just a massive solid wall.
That's a great way to look at it.
Right. And on one side of this wall, you have the business. That side holds the company's debts, its vendors, its payroll obligations. And on the other side of the wall is your personal life, your savings account, your retirement, your kids' college fund, your house.
Right. They are totally separate.
Exactly. When the business borrows money and only the business signs the loan, that wall holds firm. If the company fails, the lender is stuck on their side of the wall, just, picking through whatever office furniture or inventory the company left behind. They cannot legally climb over the wall to get to your personal bank account.
That visual illustrates the legal boundary perfectly. So what happens when you sign a personal guarantee? You are voluntarily reaching your own arm over that brick wall and saying to the lender, hey, if the company fails to pay you, I will.
You're bypassing the wall yourself.
Exactly. You are creating a completely separate secondary contract. And this is the legal mechanism that catches people off guard. Because it's a separate promise, the lender does not have to prove you did anything wrong to enforce it.
Hold on. So they don't have to show you, embezzled money or mismanaged the business or bought a sports car with company funds?
No, not at all. They do not have to argue you abused the company or, pierce the corporate veil in front of a judge. They simply pull out that secondary contract, point to your signature, and ask you personally to pay.
Wow.
And the wild part is the wall is actually still standing for everyone else. Like if you had a silent partner who refused to sign the guarantee, the wall protects their personal assets perfectly.
Oh, because they never reached over it.
Right. It just does absolutely nothing for the person who physically signed that piece of paper. In one stroke of a pen, the company's problem became your personal problem.
Which naturally brings us to the first thing anyone listening is probably trying to figure out right now. Did I actually sign one of those?
Right. The million-dollar question.
Literally, in some cases. Let's break down the rules of the game here. Who is actually required to sign these things?
Well, we should start with the traditional rules for your common small business administration loans. The standard SBA loans people use to buy an existing business or secure working capital or purchase heavy equipment.
Right.
Whether you had to sign comes down to a very specific underwriting metric, how much of the company you own. The general standard is the 20% rule. If you own 20% or more of the business, You almost certainly had to personally guarantee that loan.
Wait, what if I own 19%? If 20 is the magic number, can I just keep my ownership just under the wire and avoid the liability?
Yeah, lenders anticipate that exact strategy. It's crucial to understand that 20% is the floor, not the ceiling.
Okay, meaning they can always ask for more.
Exactly. The SBA requires a guarantee at 20%, but the bank actually originating the loan can and often will ask owners who hold 10 or 15% to sign if the bank feels nervous about the overall credit risk of the company.
So if you're at 20% or above, you sign.
Definitely.
If you're below it, you still might have.
Yep, you still have to check the paperwork.
And there is a newer wrinkle to this rule that we have to talk about, right? Specifically for people who are in the middle of a business transition or planning a buyout.
Yes, this is a critical mechanical shift for anyone planning to sell their business, applying to loan applications and business sales from mid-2025 forward. The SBA has tightened its risk posture dramatically.
How so?
Under this new framework, if you sell your company but you decide to keep even a tiny slice of equity, literally a 1% stake, you can be required to personally guarantee the entire loan for a full 2 years after the sale.
Wait, keeping 1% equity puts me on the hook for the whole $1 million loan? How is that even logical? Why would anyone ever agree to that?
I know, it sounds crazy, but it fundamentally changes how mergers and acquisitions are structured. Historically, keeping a small piece of the pie for future upside was a very routine way to structure a buyout.
Right. You want to stay involved just a little bit.
Exactly. But the SBA is attempting to ensure that whoever is tied to the business still has serious skin in the game. And they included a look-back provision to prevent people from just gaming the system right before the sale.
How does a look-back provision work in practice? Like, give me a timeline.
Okay, let's look at a timeline. Suppose you own 100% of a company. In January, you sell 90% of it, keeping 10% for yourself.
Okay, so I'm well under 20% now.
Right. Then, in March, the new majority owners apply for an SBA loan. Even though you only own 10% at the time of the application, you owned more than 20% within the 6 months prior to the application.
Oh, wow.
Yeah, because of that look-back window, the government still requires you to personally guarantee the new debt. The only clean way out under these new rules is a total exit where you sever all ties.
That is a massive trap for the unwary seller.
But I want to pivot to the elephant in the room here. We've been talking about standard SBA loans and business acquisitions.
Right. What about the pandemic loans? Because millions of businesses in Houston and across the country took those disaster loans just to survive the lockdowns. I'm talking about the EIDL loans. Do these same ownership percentage rules apply to that disaster money?
No, and this is where a vast amount of the current confusion originates.
Okay.
First, EIDL stands for Economic Injury Disaster Loan. During the pandemic, the government realized that standard underwriting, analyzing ownership percentages, looking at historical cash flows, doing deep background checks, that would take months.
And businesses were failing in days.
Exactly. So for the COVID EDL loans, they threw the ownership percentage rule out the window entirely. They used a blunt, hard dollar amount instead.
The $200,000 threshold.
That's it. $200,000 is the dividing line. The mechanism was incredibly straightforward. If your COVID EDL loan was $200,000 or less, you generally did not sign a personal guarantee at all.
So no guarantee at all under $200K.
Right. The debt belongs strictly to the business entity. If the business is gone, the legal mechanism to reach you personally is incredibly weak or really non-existent. But if your loan was above $200,000, even if it was $200,001,
Just $1 ever.
just $1 over, you were required to sign a guarantee and you're personally liable for the entire balance.
Man, to really make this contrast land, let's picture two identical Houston businesses.
Okay.
Let's say they're both local logistics companies operating right down the street from each other.
Okay, side by side.
Yeah, both are small companies,
Yeah.
both have a single owner, and both were hit hard by the supply chain crisis. And sadly, they had to liquidate their trucks and close their doors.
A very common story, unfortunately.
Right. Now, the first owner borrowed $150,000 in COVID EIDL funds. The second owner borrowed $450,000. Walk us through the mechanics of what happens to them now.
Well, we are looking at two completely different legal realities based on a single variable. For the owner who borrowed $150,000, they signed no personal guarantee.
Because they stayed under the line.
Right. When the logistics company formally dissolved, the debt basically died with the entity. The brick wall we talked about earlier, it held firm. The government is left holding an unsecured claim against a business that no longer exists.
And the second owner, the one at $450K.
The owner who borrowed $450,000 crossed the threshold. Because of that, the loan documents included the unconditional guarantee. Now that their logistics company is closed, the wall is bypassed. The U.S. Treasury views that $450,000 balance as the personal individual debt of the owner. They are facing the full weight of federal collection.
Same exact business model, same economic failure, but totally opposite personal exposure.
Yeah,
That just reframes how anyone listening should think about their own situation.
it really does.
Because if you're struggling with a closed business, your first step is not logging into a portal to check how big your balance is. Your absolute first step is figuring out which side of that $200,000 line you landed on and whether your signature is actually on a guarantee.
That is the pivotal diagnostic question. Until you know whether you actually signed, worrying about the balance is totally premature.
Okay, but let's assume the worst case scenario. You borrowed over 200 grand. You definitely signed the guarantee. The business is closed, the loan defaults, and the SBA hands your file over to the U.S. Treasury for collection.
Right, it goes to Treasury.
When people get these Treasury demand letters, the psychological panic is immediate. The assumption is that the government has a button they can push to just come and take their house on a Tuesday. I want to dig into the mechanics of collection here. What can they actually do?
Separating the collection myths from the actual legal mechanisms is vital for calming that initial panic. The government possesses powerful collection tools, absolutely, but those tools have very specific limits. When a government-backed loan goes to the Treasury, they activate what we call administrative collection powers.
What does that mean, practically?
This means they do not have to go to court, file a lawsuit, or ask a judge for permission to start taking your money.
They just bypass the judicial system entirely.
For certain assets, yes. Administratively, they can do three very specific, very painful things. First, they can intercept your tax refund. If you overpaid your taxes and the IRS owes you money, the Treasury simply intercepts that transfer at the federal level and routes it to pay down your loan balance.
So that never even hits your bank account.
Never. Second, they can take a slice of certain federal benefit payments, which can actually include portions of Social Security. And third, they can institute an administrative wage garnishment, ordering your employer to withhold a percentage of your paycheck and send it straight to the government.
Okay, let me challenge that last point, because wage garnishment sounds ruinous. If they garnish my wages, how much can they actually take? Am I going to be left with $0 to feed my family?
No, you will not be left with zero. And this is where understanding the mechanics helps lower the temperature a bit. Federal law caps administrative wage garnishment. Typically, they can take a maximum of 15% of your disposable pay.
Okay, 15%.
Right. It is undoubtedly a painful pay cut, and it will hurt your household budget, but it is not a 100% seizure of your livelihood. Furthermore, they usually tack a hefty collection fee onto your total balance, sometimes approaching 30% of what you originally owed, just to cover their own administrative costs.
A 15% pay cut and a 30% fee markup is terrifying. But notice what is missing from your list of administrative powers.
Taking real estate is completely missing. Those automatic administrative tools only reach your income, your tax refunds, and your federal payments. They do not by themselves grant the government the legal authority to seize your home or your commercial property.
So there really is no magic button for the house.
Oh, there is no magic button. Taking real property is a much higher legal bar. It generally requires one of two things. Either the government has a pre-existing legal claim on that specific property, like a mortgage, or a deed of trust that you signed when you got the loan.
Right, which you'd know about.
Yes, or they have to do it the hard way. They have to actually file a lawsuit against you in federal court, win the lawsuit, obtain a formal judgment from a judge, and then attempt to execute that judgment against your real estate. And even then, that is subject to state homestead protections.
This distinction is massive. It is the exact reason why practitioners at North Star Law Firm tell their clients not to panic. They see business owners who are so terrified by a Treasury letter that they immediately drain their 401ks or cash out their children's college funds to pay a debt that was never legally going to reach their house in the first place.
Exactly. You have to know what the government can actually reach before you start liquidating your future.
Right.
Surrendering protected assets out of fear is the greatest tragedy in this whole process. Retirement accounts, for instance, are highly protected under federal law. People drain them because they assume the government is this omnipotent force that can take everything. Understanding the limits of administrative collection is your first line of defense.
Okay, so you're breathing a little easier knowing the house is not instantly gone and your retirement might be safe. But you are still losing 15% of your paycheck and waving goodbye to your tax refunds.
Right, which is still a huge problem.
Right, so how do you actually get out from under this permanently? A lot of people assume that because it is government debt, it is invincible. They think it's like student loans, where you were basically stuck with it until you die.
Yeah.
Is government business debt permanent?
Busting that specific myth is perhaps the most important thing we will do today. The assumption that an SBA or EIDL personal guarantee is glued to you forever like a student loan is legally incorrect.
Really?
Yes. A personal guarantee on a business loan is classified as ordinary business debt. It is not in one of the special protected categories. It is not a student loan. It is not unpaid child support. And it is not a penalty for a recent tax fraud.
Meaning what exactly for the listener?
Meaning a qualifying business owner can absolutely eliminate their personal liability on that guarantee through the federal bankruptcy system.
Wow. Okay, I want to picture how this mechanism actually works. If dealing with Treasury collections is like playing a board game where the government gets to move all their pieces at once and take your money, is filing for bankruptcy like freezing the game board?
Freezing the game board is an excellent way to conceptualize it. The instant a bankruptcy petition is filed, a federal injunction called the automatic stay snaps into place.
Okay.
It literally pauses the game. The Treasury loses their dice. That legal shield immediately stops the tax refund interceptions. It legally halts the paycheck garnishment. It forces an end to the collection letters and the harassing phone calls.
Just instantly.
Instantly. Every player on the board has to stop moving immediately by order of federal law while a judge sorts out the rules.
That is incredibly powerful. But let's look at the holes in that shield, though. I'm sure it is not a flawless, get-out-of-debt-free card. Where does the automatic stay fall short?
Well, you have to be very clear-eyed about two major catches. The first catch involves secured debt, specifically liens. Wiping out your personal liability in bankruptcy does not wipe out a mortgage or a lien on specific real estate.
Explain the mechanism there. Why does the lien survive if the debt is wiped out?
Because a secured loan is actually two separate legal concepts. There is the personal promise to pay the money, and there is the lien, which is the bank's claim on the physical dirt and bricks. Bankruptcy wipes out the personal promise to pay. They can never garnish your wages again. But the lien on the physical property survives the bankruptcy intact. If you pledged a specific commercial building as a collateral, the government still has a claim on that building. You cannot assume bankruptcy magically clears the title to your real estate.
Right. That distinction between personal liability and the actual real estate lien is huge. And the second catch?
The second catch revolves around fraud or material misrepresentation.
Okay.
Yeah, if the original loan was obtained using a financial statement or an application that was materially false, for example, if an owner fabricated their historical revenues, actively hid who actually owned the company, or, committed overt fraud to get the disaster money, the government can fight to keep that particular debt from being erased.
They can actually challenge it.
Exactly. They can file an objection to the discharge, arguing that because the money was stolen through deception, the debt should survive the bankruptcy. Honesty on that original application matters immensely years down the line.
Okay, so assuming the borrower was honest, and assuming we understand whether a lien exists, freezing the game board really is a navigable path. But how does the game actually end? I know bankruptcy isn't just one single process. Walk us through the different tracks. How do they mechanically work?
Well, the right track depends entirely on the current state of the business and the owner's personal assets. Let's look at the three most common paths. First, if the business is truly dead, the doors are closed, the equipment is sold, and you just need the personal guarantee severed. A straight liquidation, known as a Chapter 7, is often the most direct route.
Okay, how does that work?
The mechanism here is simple. A trustee looks to see if you have any unprotected, non-exempt personal assets. If you do, they are sold to pay creditors. In exchange, your personal liability on the guarantee is wiped clean, usually within a few months.
What if the business isn't dead, though? What if you have a great restaurant or, like our earlier example, a solid logistics company, but you are just suffocating under the monthly debt service of this massive government loan.
In that scenario, you would look at a small business reorganization. This track lets a viable company freeze collections and forcibly restructure what it owes. You can often stretch out the repayment terms, reduce the interest rates, and keep the doors open while managing the debt.
That makes sense.
And what is truly fascinating about recent federal court rulings is that this reorganization door has been opened even to owners whose businesses have already closed.
Wait, how can a closed business reorganize? There's nothing left to operate.
Right. The entity itself might be dead, but the individual owner is now holding a massive pile of business debt because of the guarantee. Courts are increasingly allowing those individuals to use the small business reorganization rules to restructure their personal obligations.
Oh, I see.
Yeah, often resulting in paying only a fraction of the original guarantee over time based on what they can actually afford while protecting their personal assets.
And if someone doesn't qualify for that, but they have a steady W-2 job now, they moved on, they're employed elsewhere.
Then they utilize a court-supervised repayment plan, known as a Chapter 13. The mechanism here is a 3 to 5 year payment plan based on your disposable income. It acts as a shield to protect specific assets, like a home that might have equity over the state exemption limit, while you catch up on what you can afford. At the end of the plan, the remaining unsecured guarantee balance is typically discharged.
Hearing the mechanics of those three tracks makes it incredibly obvious why trying to navigate this alone, based on late-night Google searches, is just a recipe for disaster.
It really is.
The track you choose, how you time the filing, it can literally be the difference between keeping your home and losing it.
That is the most vital takeaway we can offer. Getting a Treasury demand letter for $500,000 feels catastrophic. I mean, it ruins people's weeks, their months. But it is a strictly navigable legal process. You just need a map and you need to understand the terrain.
Which brings us to the bottom line of this entire deep dive. If you are sitting there in Houston or anywhere else, losing sleep over a closed business and a mounting treasury balance, the total dollar amount you owe matters far less than two simple questions. Question 1, did you actually sign a personal guarantee?
Right.
And question 2, is there a lien recorded on your real estate? Answer those two questions, and the path forward usually becomes remarkably clear.
Exactly. Knowing the concrete answers to those two questions is the only way to prevent the worst possible moves a borrower can make. Panicking, liquidating protected retirement accounts, or simply ignoring the mail while your options quietly close around you. There's almost always a path through this, but the earlier you map it out, the more choices you still have available to you.
If this scenario is hitting close to home, or if you were a CPA, a bookkeeper, or an advisor trying to counsel anxious clients through this right now, this is where you need practitioners who actually understand the intersection of treasury collection and bankruptcy law. You can look up North Star Law Firm. They are based right here in Houston, at htx-legal.net to help diagnose your specific situation.
Yeah, getting a professional to review the actual loan file to locate that signature page before making any decisions is just the most critical first step.
Absolutely. And you can also check out Philip Zagotti's books, Taxed and Trusted, which are fantastic deep dives into tax defense and trustee obligations. But I want to leave you with a final thought to mull over, looking at the bigger economic picture.
Okay.
We've spent this whole time talking about the individual small business owner.
Yeah.
But zoom out for a second. With commercial real estate struggling and consumer spending shifting, what happens if thousands of these government guarantees are called in at exactly the same time?
That's a scary thought.
Right. If thousands of local business owners suddenly have 15% of their paychecks garnished by the Treasury all at once, could a wave of commercial business failures quietly trigger a much larger consumer debt crisis? The math on that is staggering. The wall between business failure and personal ruin might be thinner than we think, but, well, at least now you know the mechanics of how to build a shield.
Thanks for listening to the North Star Law Firm podcast. This podcast is produced for general educational and informational purposes only and should not be construed as tax, legal, financial, or accounting advice for any specific situation. Listening to this podcast does not create an attorney-client or CPA-client relationship with North Star Law Firm. Tax and legal outcomes depend on the specific facts of each matter and on applicable state and federal law, which varies by jurisdiction. If you have a matter that requires professional advice, consult a qualified attorney or CPA licensed in your jurisdiction. For further inquiries or to start a conversation, visit us at htx-legal.net. Copyright 2026 North Star Law Firm. All rights reserved.